In March 2020, Manuel Ellis died while handcuffed in police custody. 3 officers involved in the incident are now on trial. Thank you for joining us. I'm Christine Pei. For the duration of the trial, King 5 will recap the biggest developments in the courtroom, and we will discuss what it all means. Today, we sit down with attorney Mark Lindquist, who served as a Pierce County prosecuting attorney for nearly a decade, and criminal defense attorney Sarra Marie from the Marshall defense firm and a former King County public defender. Thank you both for being here. We so appreciate it. We have a lot to talk about this week. This week, by the way, the state has rested its case. And taking a look back at opening statements more than a month ago, how did witnesses support or contradict the state's case? Let's take a listen.
None of this should have happened. Mr. Ellis should not have died that night. Evidence will show that Mr. Ellis did nothing wrong. You'll hear from 3 eyewitnesses at the intersection, and these 3 eyewitnesses will tell you what they saw.
Did you see anything that was aggressive or threatening that you witnessed from Mr. Ellis?
No. You certainly didn't see Mr. Ellis strike the front passenger window of the patrol vehicle. Is that right?
Right, I didn't. I honestly don't remember him taking steps anymore. I just remember him turning around and getting knocked down. So I don't know if he took steps or if he didn't.
And she got out of her car and started yelling,
"Stop hitting him! Hitting him, just arrest him!"
"Can't breathe, sir. Can't breathe. Still can't breathe. Still can't breathe, sir."
Yeah, any time a person has a stated or observable disability of any sort, then you want to get them cleared medically right away.
The paramedic found Mr. Ellis unresponsive.
His body was not breathing adequately on its own to sustain life.
Even if Mr. Ellis said, "I can't breathe, sir," once, that should have been enough for the officers to help him, to do something for him. But they didn't.
So as we heard there, state prosecutors have said they would prove to the jury the following: that Manuel Ellis did nothing wrong on the night he died, that police officers had no legal authority to punch or tase Ellis, that police violated their training by not moving Ellis out of the hog-tie position, and that police heard Ellis say he couldn't breathe, which contributed to his death by not getting him the help. Now, turning now to both of you, do you think the prosecution was able to deliver to the jury what they promised in those opening statements? I'll start with you, Mark.
That's important, as we discussed earlier, and I think for the most part they did. Probably could have done a better job, though, of warning the jurors of some of the shortcomings in their case. And you do that for a couple of reasons. One is so you look like you're being totally open and transparent about the evidence. And secondly, so you can steal the thunder of the other side. And they didn't, for example, warn the jurors that the Pierce County medic was going to get up on the stand and blame excited delirium for the death. You know, basically blame the methamphetamine and the agitation. And that's something I think they could have softened the blow on, and they didn't. And there are a couple other examples of that. But as I said, for the most part, I think they delivered on what they promised.
So, you know, we have so much more to parse out, but let's revisit another part of this case. Let's actually take some time to review the charges, what the officers have actually been charged with. Matthew Collins and Christopher Burbank were the 2 officers involved in that initial encounter with Ellis. Both Collins and Burbank are charged with second-degree murder and first-degree manslaughter. Timothy Rankin, who was one of the responding officers to arrive during the incident, is charged with first-degree manslaughter. So let's open it up. Mark, what must prosecutors prove to secure a conviction in this case? And could you also break down what those charges entail?
Sure. So 2 things they need to prove as to the murder charges. Number 1 is that the officer's force was unreasonable, excessive. And number 2 is that that force caused the death of Mr. Ellis. So most of our witnesses have been focused on one of those 2 issues, either the use of force or the cause of death.
You know, the 2 of the officers, Collins and Burbank, they have the second-degree murder charge in addition to the manslaughter, and Timothy Rankin has only the manslaughter charge. Why might that be?
So Rankin was not involved in the beginning of this encounter, and the only actions that Rankin were involved with were toward the tail end of restraining Mr. Ellis, and he's only been charged with manslaughter. So they do not have to prove that Officer Rankin intentionally insulted Mr. Ellis, but rather just that he was reckless. Sure. So much lesser standard than what they need to prove against the other 2 officers.
So Sarah, taking kind of just a perspective on the defense side, what extra protections or defenses do police officers have in facing a charge like this?
I think that's changed a whole lot over the last couple of years with a lot of the changes in how people see police officers. I think while not necessarily a legal defense, there's always been an understanding of police as being seen as upstanding members of the society, people that are doing their job, that are doing their best. And so there's almost an unspoken understanding that force is appropriate. And that's really changed a lot over the last couple of years. To some extent, where some people will almost assume the opposite, and you never know with jurors and with people that you're talking to what kind of presumption you're going to get at this particular point. As far as what you're looking at legally, and in this case, I don't know that there's a specific difference as far as the elements. Obviously, the state's still going to have to prove the same elements. Yeah. It does come up when we're talking about what is use of force, what is, there's been a lot of discussions about how much can come in about their training, whether they followed appropriate use of force protocols and things like that. And so those are distinctions that you wouldn't have when it was a civilian, for instance, charged with the same crimes.
On the day the prosecutors rested their case on Wednesday, the defense attorneys asked the judge to dismiss the charges altogether. Could you explain whether this was common to see that, and what grounds did they have for the request from even suggesting that? Your thoughts?
I mean, it is pretty common. There's strategic reasons both ways as to why you might or might not do that in any given case. For one, it gives you a second bite at the apple in some ways. If you don't know what a jury is going to say, but you can convince a judge that there's no way a jury could make this determination, then you don't have to roll the dice about a jury making an emotional decision, because it's really difficult to go back and say, this jury made the wrong decision. They didn't have the support for that. And so if a judge says that ahead of time, you never get there. Yeah. But, sorry, go ahead.
And well, of course, so the judge pretty much shot it down. Like those charges still stand. I mean, do you think the prosecutors were surprised to hear that from the defense?
The thing to understand about that motion to dismiss is commonly called a halftime motion to dismiss. It is never granted. Zero chance. Both sides know that.
Just get it in there, right?
Yeah.
Just get it in there for the record. Yeah.
Exactly.
Yeah. Okay.
Exactly.
So, you mentioned use of force and everything that goes along with that. Going back to this past week, use of force expert Jack Ryan took the stand as one of the state's last witnesses and guests. King 5's Lionel Donovan is in Tacoma with a look at Ryan's testimony.
After the prosecution wrapped up its case on Wednesday, the defense called on the judge to throw out the case entirely and to dismiss the charges against the officers. Ultimately, the judge decided that the charges would stand and the trial will continue.
Correct.
This week, the testimony of the prosecution's main witness regarding Manuel Ellis's arrest could be summarized in a single phrase.
Totally inappropriate response.
Totally what?
Inappropriate response.
The jury spent the week hearing from Jack Ryan, a police practices expert who travels around the country teaching police officers the use of force tactics. During his testimony, Ryan explained how police officers are trained on the acceptable use of force and analyzed witness video of Ellis's arrest. He noted the tactics to subdue Ellis, which included hand strikes, chokeholds, and using a taser multiple times, which continued after Ellis was on the ground.
Once the attack ends and you've got him on the ground, you can't keep hitting him.
Well, he's not restrained at that point, is he?
No.
And he's actively resisting, right?
I don't see active resistance there. He's on his back with his feet in the air.
In court, Ryan pointed out that while Ellis was on his stomach, Officer Rankin stated he placed his weight on top of Ellis. Ryan says that goes against training, and officers are instructed on the dangers of putting someone on their stomach because it could impair breathing.
It's inappropriate to put pressure on somebody's back after they're handcuffed. It's inappropriate to leave them in a prone position after they're handcuffed.
The defense questioned the officer's ability to notice Ellis having difficulty breathing while he was on his stomach. But Ryan says Ellis's "I can't breathe" statements were clear.
And I can't get in their head and say what they heard, but I can say that if you can hear it from a doorbell from a distance away, they should have heard it.
In the end, Ryan says based on the video and officers' audio interviews, the collective use of force used against Ellis was excessive.
Force is fluid. So, when a subject is doing a lot of resistance, then you get to meet that resistance with a certain degree of force. As the resistance goes down, then your force has to go down with it.
Once court resumes Monday morning, the defense will focus on presenting its case in the hopes of establishing reasonable doubt in the jury. From the Pierce County Courthouse, Lionel Donovan, King 5 News.
Our Tacoma Bureau Chief has been following this case very closely. We just got the recap from this past week. We'll get into use of force witnesses a little bit later, but let's talk about the order in terms of how the witnesses took the stand and who in that order was able to testify. You could say that some of the most impactful witnesses appeared on the stand relatively early on, like Sarah McDowell, Seth Cowden, and Ayanna Malang, who provided video of the scuffle, the video evidence. We also heard from Ellis's own mother and sister very early on. So when we think about the order of the witnesses presented on the state's case, Mark, what might be the strategy here? We heard from the sister and the mother early, and we heard from a use of force expert last. What might the prosecution be going with here?
Well, as we've talked about earlier, the strategy is to start strong and finish strong, based on the theories of primacy and recency. Jurors tend to remember what they heard first and what they heard last. They started with emotion, which I think is a smart choice because jurors are moved by emotion as well as facts, maybe more so. But instead of finishing on emotion, which is pretty typical in a case like this, they decided to go with a use of force expert.
Well, we also heard from a lot of medical experts.
Right.
At one point, Mark, you said it was a little bit of overkill. I'm just going to list them where you have an outside independent forensic pathologist. We had the actual retired medical examiner, a paramedic, cardiologist, a pulmonologist. Do you think that was a long list? Is that pretty necessary?
I don't think it's necessary in a criminal prosecution. That's more the witness list you'd expect to see in a civil case. But the prosecution had their reasons. They've done a lot of what I would call hedging their bets. Well, if you don't like this theory, we've got another theory for you.
So going back to Jack Ryan's testimony, who we heard from in Lionel's recap from this past week, Jack Ryan, how do you think how do you think the jury is going to be taking his testimony?
Well, in terms of finishing strong, I can see why they thought he'd be a strong finish. One, he's a former police officer. Number two, he's done a lot of training. That gives him credibility. And number three, he just presented professionally. He stayed very calm and cool under a long time of cross-examination. Now, that said, something went a little awry in his testimony that the prosecution probably did not anticipate, and there's no reason they should have anticipated this, but the judge decided to interject himself into the questioning, which is not unprecedented but unusual. And you will recall at some point the judge basically said to the witness about use of force, "You're wrong."
Yeah. And that was the moment where I believe it was Patty Eakes who kind of interjected and said, could you address the jury for a moment and kind of maybe take that back a little bit? And how did he respond?
Well, the prosecutor was understandably concerned that the jury could have interpreted that as the judge undermining the credibility of a key witness.
Yeah.
And so she wanted an instruction that says the judge should not comment on the credibility of a witness or the weight of the evidence, and that if it appears he did, the jury should ignore that. Yeah. And what the judge said is, no, I'm not going to give that instruction now, but at the end of the case, there is a standard instruction that tells the jurors that the judges are not to weigh in and give their personal opinions on the evidence, that the judges of the credibility of the witnesses are the jurors, and strictly the jurors.
Now, turning to what we can expect for next week when the defense makes its case, Sarah, I'll direct this over to you. Would you assume that the defense attorneys for each of the officers will work together or perhaps band apart? Because we heard some moments during the testimony on the prosecution side, even in some of the objections, some attorneys for one of the officers would maybe go against and kind of protect their client versus the other client. How do you see things going for next week and beyond?
It's hard to say. We aren't going to ever know exactly what they're saying to each other, so we're guessing a bit. I would expect that they're probably working together on some level. These are officers that have worked together. In some ways, they have very compatible defenses, but also they each have their own roles. And at the end of the day, from their defense attorney, their attorney is going to be fighting for them specifically. And if that means throwing something to a different attorney or risking another of the defendants, of the co-defendants, looking worse, the attorney's probably going to do it. That said, I think there is some strategic things they can very much work together for, because one of the nice things about co-defendant cases from a defense side is you get multiple opportunities to say the same thing. Because while there's only one prosecutor, you get 3 defense attorneys that can all say the same thing. And I think an interesting point that comes up is how they've handled opening statements, right? The prosecutor got one opening statement and it was given and it's done, and that's the start of their case, and they go present their case. In a typical case, you would see the defense doing the same thing, right? You can usually and almost always want to present a opening statement at the start, if nothing else, because you're going to hear however long of the prosecution's case, and this is your one chance to get some words in. But when you have 3 defense attorneys, you can do exactly what they did here and have some opening statements now and then reserve. And so now they essentially get arguments at the start, arguments in the middle, and they're going to get to do closing arguments at the end, much less 3 of them.
So to be clear, we heard the opening statements for, I believe, the lawyer presented it for Officer Burbank and Timothy Rankin, but we have yet to hear the opening statements, I believe, for Officer Collins. Is this common? Can we, I mean, is this allowed even, that the defense can withhold one of the opening statements for the middle when we can hear it next week?
The judge always gets to decide the presentation of evidence and how a case goes, so there's no rule saying that it can't be done. It would be really interesting to have Judge Tollefson here to give us his exact thoughts on how appropriate that is, but certainly it's allowable under the rules. It is unusual. And I could certainly see a prosecutor saying it gives some undue influence or some options.
We never win that argument, though. The judge is going to let them do it this way. I've seen it done before, and I agree with you. The repetition for the defense is valuable, and the idea of giving 2 opening statements rather than 1, they get to time it at the beginning and then again before they put on their case, again, advantageous.
And I think it sounds like he will deliver it on sometime, I think, this upcoming week. So we'll have to wait and see what else is being said. You know, we now know that the state has presented its case. We saw some issues come up. One of them, it came up a number of times, especially in hearing from the medical examiner's report and all of the other medical experts, is the spit hood. And the officer who applied the spit hood on Ellis has not been charged, and none of the officers charged here had anything to do with the spit hood. Do you think that this might be coming up later in the defense's side?
Absolutely, and I think actually this goes back to exactly what you were asking about, are the defenses going to break apart? Because not only do the different officers have different roles, there's officers that were involved that weren't charged, and so I absolutely think that they're going to be bringing that up, and particularly for the officer that's not charged and doesn't have his own ability to present a defense or to say, I know I wasn't the one at fault. Absolutely, I think all 3 of them are going to try and place some blame there. Anything they can do to shift attention away from them and say we weren't the actual cause.
Yeah, Mark, your thoughts on that?
Oh, I completely agree. The defense is going to go to town on that. Yes.
Okay. So going back to the list of the witnesses, we heard from a lot of medical experts, but there seems to be a lot of focus on that, the cause of death versus the use of force side. We really only heard from maybe just Jack Ryan, and I think there was another use of a police trainer whose testimony wasn't even permitted sometime in the middle of their case. Do you think that there was an imbalance in that, or is that about right when the prosecution makes this case? The medical experts versus the use of force?
Well, as we discussed earlier, they did put a lot of emphasis on the cause of death, and they brought in some experts that weren't even entirely consistent with each other, let alone the rebuttal we're going to hear from the defense experts. So I think actually it was not balanced, and I think too much emphasis was placed on cause of death, which tended to betray maybe a lack of confidence on that issue.
Interesting. A couple of weeks ago, we heard from David Marshall. He was one of the attorneys who was here, and he brought up a good point about, Ken Liu, who from the state attorney's office, he delivered the opening statements. He started with that line, I can't breathe, sir. And it had been, I think, their goal was to keep this underlying theme. Do you think the prosecution achieved that?
They did. Kent Liu, that was a first phrase out of Kent Liu's mouth. He's a former Pierce County deputy prosecutor now with the AG's office. like everyone else in this courtroom, he's an experienced trial attorney. They knew their theme and they stuck to their theme, and that's one of the things I think I would give them credit for, is they've stayed consistent on that theme.
Sure. So, really, in terms of just, I don't want to say a scorecard exactly, but now that the prosecution has wrapped up its case, we're looking ahead to another several weeks on the defense side. How do you think the state did in general? I mean, do you think they went out with a bang that they were looking for?
Well, I think the bang here, as I've said from the beginning, is going to come from the officer's testimony. And they chose not to bring in the entirety of the officer's statements in their case in chief.
Yeah.
So now everyone's just waiting to hear from the officers when they testify. And they're, as we've talked about, they're going to have to testify for the defense.
Sure.
And then we're going to see. But in terms of what they did present, they delivered for the most part on what they promised. There were some glitches in their case, but there are ups and downs in every trial. There are problems in every case. Where I think they're really going to have to make some ground. I do think they have some ground to make up. And the place that they're going to have to get there is through the cross-examination of the officers.
I gotcha. And looking ahead to the defense, it's impossible to know, right? But what might we expect? What should we really kind of pinpoint looking into the next half of this trial?
It's gonna really depend, and that's one of the interesting things I think. Looking back to like the number of witnesses that were listed and the possibilities, the defense really often is kind of hedging to see exactly what's going to come out, because they want to capitalize on any of these glitches that come up or what happens in trial. They're definitely going to be bringing up things about the other people, the other officers that weren't charged particularly and that were involved, the spit hood. They're going to be bringing up things about the methamphetamine, any other cause they're going to be pushing really hard on. But it is going to be really interesting to see, as you brought up, how much they band together, how much they point fingers at the co-defendants, the differences that are going to come up between Officer Rankin and Burbank and Collins versus because of the different timing. And so I think a lot of those things are going to be very important. And of course, their testimony is going to be very different from the initial eyewitnesses saying, here's what we saw from what we believe to be the start of the event. And then of course how the jury hears it. And they're the ones that end up deciding. It is always so interesting to talk to jurors later and hear what they hear, because anyone hearing testimony is always going to pick different details that they catch. And so we'll see.
We have several more weeks to go. This is the halfway point, and just to reinforce, this is a big case in Pierce County, in Tacoma, and we're going to hear the other side, the defense coming up. Do you have any final thoughts on how things have been, what we should be looking out for next week and beyond, and just the significance of this case, really? I'll start with you, Mark.
Well, this case is playing out differently than your average case. For example, that halftime motion, typically the defense attorney will stand up for maybe 30 seconds, 45 seconds, make the motion, then the prosecutor will stand up and say, I disagree, Your Honor, I think there's sufficient evidence, thank you, and sit back down. Whereas here, what you saw was both sides went on and essentially laid out all their evidence that we heard from their opening statement. So everything here is being played on a larger scale than it would be a typical case. But the jurors, they're seeing a lot. I'm watching a lot more of this case than your average person, but I'm not seeing the whole case that jurors are seeing.
Okay.
They're in that courtroom all day, every day. I would like to see how they react. If I was going to watch one thing, I'd watch how they react to the officers as they testify.
That is a thing from day one you have mentioned. That is what we need to hear from, definitely. Final thoughts, Sarah?
It's going to be a very interesting change to see how it changes with the defense presenting their case, especially, again, with 3 attorneys. How are they going to combine that? How much are they going to repeat? There's always a concern of losing jury interest if you overdo things, which can be an issue with 3 attorneys. But also, this in many ways is going to be the most interesting part of the case because it's the most unknown. And so we'll see what happens.
That's a very good point. Okay, thank you very much, Sarah, and thank you, Mark. As always, we so appreciate your insights. We will have more trial coverage coming up every single Friday, and you can tune in on our streaming app, King 5 Plus, available on Roku, Amazon Fire, and Apple TV. Our weekly recap is also available on our YouTube channel. As always, you can keep up to date with our trial coverage on king5.com and on our mobile app.